And again, I'm just going to remind you that during presentation today, if you have to talk or answer a phone, if you would mute yourself, if you haven't already, I'd appreciate it. This one is available, and I'll just tell you that it gives you lots of different things that you can look at for women in the law, women's rights. The Annenberg classroom thingy over here on the left is kind of weird, but it finally comes up. I checked those all again yesterday. So there's that one. And let's see, I'll go back to stopping the share on that one, and I'll show you another one real quick. That would be this one, I believe. Dower is a concept in property rights. And I warn you, these aren't just places out on the web. There's also at least one book here. It's down on the right here, called Inheritance in America from Colonial Days to the Present. It is the best ever. It's quoted everywhere. If you do not have it in your library down in Helena, I would highly recommend it. It's still available. Just the appendices in back, the 50 or 60 pages, they give you everything in just a very brief way about each state, and they show you how laws have changed in those states. And the other one that is really fun is the marital signature requirements for land sales, because this site will take you out and just show you state by state what you have to do. And there's one more free book down near the bottom. So there's that one. You've got a set of notes. Let's see, share screen. You've got a set of notes from me that you have available, and I don't see that up on my screen right now. I just going to show you one more thing that is available that is very good. And this site is good for more than just this particular topic. This one is the legal status of women site, but it's also the advanced placement information site for sophomores, juniors, and seniors in the United States who are taking advanced placement U.S. history. And it does a really neat thing. I warn you, this is a 3-pager from the same women that I showed you on that book. It just gives you a fast overview of this topic and lets you know what high school kids are learning if they're taking those advanced placement topics. And all sophomores, juniors, and seniors are eligible to take that class. And by the way, in Great Falls and Bozeman, I know, and in Billings, a lot of people take AP. I'm assuming they do also in Helena. But this is a really great site for more than just this legal status of women thing. But it'll give you a fast overview if you're looking for things. And I think you have that available. And now I'm going to actually go to the actual share, hopefully, and come in with my, can you see that presentation?
No.
No, okay. All right, so I need to go to the share screen presentation. Of course I do. Share screen, and I want to go here. Now, can you see it?
Yeah.
Okay, so we will start Dower rights, what genealogists need to know. And hopefully some of you have been involved with this topic before. It's really a pretty interesting topic, I think. I'm going to go now to the slideshow from the beginning. And we will actually begin this. Think of your female ancestors' time and context and record her rights. It is going to help you. Where did she live? Which states? Did her husband have total right over her person? And how long ago, if they finally got rid of that law in that particular state, how long ago did that happen? Because guess what, folks? There's 3 states in the United States that still have certain dower right precepts in their law. That would be Ohio, Arkansas, and Kentucky. Other things for you to consider would be, how did she gain citizenship if she came into the country as an immigrant? What about the children in the marriage? What rights did she have with them? If her husband died, why might there have been a totally separate guardianship for the children? And what property did she ever own, and what rights did she have to it? So these are just some of the questions that I have had. I have a great grandmother by name of Margaret Wart Coglizer. And what rights she had is something that I'm just beginning to consider now. I knew a great deal about her husband. Her husband was Zura Coglizer. He was one of my Civil War ancestors. I was able to follow him right to the time that he died in 1904. But his wife, Margaret, is really kind of a cipher. I could find evidence of her in the 1840 census when she was with her parents. I could find evidence of her in 1850 when she moved with her parents to Ohio, about 1850, and they get married in about 1852 or 1853, so I could find her after that, but I really know very little about her. Here's what I do know. She was born in 1838 in Scranton, Luzerne, Pennsylvania. That's a state that at that point had still dower rights and different rights concerning who would inherit in the case of a father dying or whatever. It no longer had primogeniture. People could inherit equally across the children, but there were still dower precepts attached to a widow. But that's okay, because she married Zura Coglizer and moved in 1852, and they lived in Ohio until 1870. So they lived there through the war. They lived there through various things, and she definitely had a right to a pension if he died. That was across all of the states after the war. It took a long time to get those pensions, by the way. In 1870, here's the interesting thing, Carolyn Key on this, she and her husband moved to Nebraska. They moved to a place called Weeping Water in Cass County, Nebraska, and she lived there for the remainder of her life. She died before her husband did. So the issue of what she got or what she was eligible for never came up in a particular will or probate. But I'm starting my search of her right now because I also know very, very little about her family. And because I've already searched all the more obvious things, what we call the low-hanging fruit, things like the censuses, war records, etc. I still know very little about them, so I don't know where they ended up. I think they moved back from Ohio to Pennsylvania, but I'm really not sure. So it's going to be up to me as I'm going through records to really look at more than just the obvious records like tax records. I might find them, I might not. Her dad, unfortunately, had a very, very common name, Samuel, and there are many Samuel Warts in both Ohio and in Pennsylvania. So I rather think I'm going to have to search for that family and find my answers actually through Margaret Wart Coglizer's considerable siblings. Well, you have the same issues you need to ask about your female ancestors. What civil rights did they really have, and when did they get them? Remember, we didn't get the right to vote universally across the United States as women until 1920, even though some states did have that. Some women were totally banned entry into the United States. Some women legally could vote early on. If you want to look at revolutionary times, right after revolutionary times, when New Jersey said that it wanted to join the Union. It had the right to vote, plus lots of other rights for women. But guess what those people did? In 1807, they voted those rights out. Unbelievable. And so women in New Jersey actually in 1808 had fewer rights than some other places did. You need to always be considered about the legal status of your ancestors if they had married. Now, if they were single, it was pretty clear. I can tell you that if they were single and they happened to have land or property, they got it. They got to pay for it. They paid taxes on it. You can find all kinds of records about people who are single, because so long as they remained single, they were their own bosses. But if they married, that changed in many states. Changed in most all states, in fact, until right after the Civil War. The legal status that I'm interested also in having you look at is what happened if those women were widowed? What did that look like in a will or in a session in probate court? What kind of laws did the particular state have? I can tell you that most of the 13 original states had things in which it was very important that dower rights be looked at. We'll look at what dower actually is, but in a few minutes. But what rights did they have if their dad and mom had given them land and property? What rights did they have to that later on? What rights did they have to their children? Could a guardian just take them? And what rights did they have regarding divorce? Divorce really changes from colonial times forward as people realize that sometimes marriages were miserable and there needed to be ways to get out of that. That didn't always happen in the South, but when you look at the New England and the middle states, you'll see that that was pretty well true. Well, let me show you what happens here. This is a dower rights case at Lewistown, Montana. It's in the Great Falls Tribune on November 21, 1919. And it says that, I'm just looking here to see if I need to invite anyone in. No, I don't. Okay. It says that the Supreme Court was received today in an important case of Mary M. Smith versus Sadie Hoffman. And it involved the title to the valuable Hoffman House property on Watson Street in Lewistown. The case was tried in June 1914. Remember, this is 1919, 5 years later, so it took some time. Judge Ayers presided in 1914, and he made an independent finding and judgment in favor of Mrs. Hoffman, who happened to be the second Mrs. Hoffman. No, the first Mrs. Hoffman was not Mary M. Smith. The Supreme Court, however, in 1919 reversed Judge Ayers' judgment and remanded the case with directions to make a decree that Mrs. Hoffman's title constituted only a life interest. That is, she could be in that house only during her lifetime. And in fact, in the event that she should remarry, her estate rights would be terminated with reversion to Mrs. Smith, who, by the way, happened to be her daughter-in-law, or Mrs. Smith's heirs. So I can tell you that in 1919, for instance, there was at least one pretty good, interesting court case in Montana that was finally decided by the Montana Supreme Court, saying, no, even though Sadie Hoffman says that by right of the fact that she was married to Hoffman, that she should have that house forever and ever. She had property rights. She could sell it. She could do whatever she wanted to. In fact, she could do none of those things. She had the right to remain in the house for her lifetime only. And then at her death, the estate would revert to his children from his previous marriage. So that was Montana, and a lot of other places too, still in 1919. So when you look, as we did a few weeks ago, when Linda Long shared her wonderful timeline, and we were making remarks to the fact that even there were specific references to what a particular legatee had and did not have, that depended strictly on state law. And here's what's important about Dower and its precepts. All of those laws have slowly changed over time, but they have changed state by state. So you need to look at states really carefully. The thing that we saw a couple of weeks ago, I believe actually was in Tennessee or Kentucky. I think Tennessee, however, but there were still things that needed to be looked at. Our Montana law in 1889 said that a married woman's separate property is her separate estate, free from the debts of her husband. Her separate earnings are her own property. She is granted sole status to maintain her separate estate. And a widow also still has access to her husband's personal estate, but only for that period of time in which she's still alive. So Montana law had changed a bit. But for instance, even in our state, you need to look at that very carefully, because that separate property only referred to what she brought to the marriage.
Is that muted or not? Is that muted?
The American colonies adopted the English system of property ownership, that is for married women, meaning women could not own property in their own name or keep their own earnings, but they did have a few rights. There were some things that they did have, but when we got to colonial times, even if a New Jersey had a different idea for its women, American colonies largely adopted that English system and still kept that common law going forward, even though we became the United States of America. So what is a dower right? It's an estate for the life of the widow in a certain portion of real estate of her husband, to which she did not relinquish her rights during the marriage. Now, she could have relinquished them if she went to a private hearing in a court where she agreed that her husband needed to sell some land, and the court would have talked to her individually without her husband or a member of her family in the session to make sure that she was not being coerced. Of course, probably coercion still happened in some ways. I'm going to show you some things that happened in Montana. Of all lands to which another was seized, and any lands to which at the time of his death he had perfect equity, having paid the purchased money therefore. So again, you need to look at every single state. What people generally said is, if a man died, the husband died without a will, then the dower right actually at least gave the woman 1/3 of the husband's real estate or rights, with some other dower rights attached. But you need to look at each state. And that book that I've given you earlier, Inheritance in America from Colonial Times to the Present, you need to look at that very carefully, because it has wonderful advice for you regarding every state, not only at the point in 1890 where most of the laws had changed, but also again in 1982, taking us pretty much up to right now. I can tell you that as of advice from 2021, there's still those 3 states with varying kinds of dower rights and still using varying kinds of dower definitions. And that's important. You need to look at what they're using, what each state is using as its term of information for dower, if it still uses that term or has something that is very similar. It's a common law tenant. It started in, well, we can find it in the English Statute of Distributions of 1670, with 1/3 under common law. But the separate property, if she came in with separate property given to her, that would be managed by her husband, and he could take any of the profits and rents for his own enjoyment. Rats. Such property became hers only by right of survivorship. And one wonders, you see many women remaining single if they had property given to them by their family. Many of those women remained single after their husband's death because they discovered they had right of survivorship. He also owned his wife's personal property. So he even owned her bed. He owned her dishes. He owned her clothing other than 2 dresses. Frequently, that was the most common thing, was that she had the right to one dress she was wearing and another one to change out of for Sunday wear. A woman couldn't enter contracts by herself. And if you're looking at the laws, for instance, for California, New Mexico, Arizona, Florida, Louisiana, Alabama, and Texas, you need to look very carefully at property rights and dower precepts, because those could also be different in French and Spanish civil law. And especially in those states, they have a history of some French and Spanish civil law precepts still standing. So you need to be very, very careful of that. Bill Dollarhide, in his books that he's completed in the last 15 years regarding what kind of various law, actual, not just laws, but civil records, what kind of things exist, he will tell you about what exists regarding French and Spanish civil law for those states that have a background. For instance, for California, especially for New Mexico, for Arizona. Texas, again, is different, remember, because it was a republic before it decided to ditch its republic and become part of the United States. So you have to be very careful in looking at these laws. If you're out there and you see something that looks pretty good, I would tell you, trust in it, but still verify. In 1765, that legal definition of married women that carried over into our country, doggone it, was the husband and wife are one person in law. That is, the very being or legal existence of the woman is suspended when she marries. Scary when I think about it. Courtesy, again, I'm not going to spend a lot of time with this, but it was a principle in common law that said a widower, remember the widower is male, could use his deceased wife's property, which she had acquired and held in her own name, until his own death. But he could not sell or transfer it to anyone but the children of his wife. Now you're going to find lots of cases, especially in Maryland and in Pennsylvania, in New York. You're going to find many cases there where that was fought and where people said, but wait a minute, these kids came with me beforehand. Shouldn't they be also entitled to some of her land or property? So remember, each and every time one of these laws are made or they're referred to in court, they're also going to tell you that there's lots of case law. There's lots of places to look in terms of wills and in terms of probate cases and so on. Most states today in the United States, other than those 3 that I named, explicitly require that 1/3 to 1/2, remember, it's via whatever the state says, 1/3 to 1/2 of a wife's property be given outright to her husband at her death if she dies without a will, that is, intestate. It's occasionally used to refer to a widower's interest as surviving spouse in the property, but most states have officially abolished the terms courtesy and dower. So if you see those still lurking around, be careful. There will be special definitions attached. A good place to go and a free place to go is to go out online, just to the Law Dictionary organization, or you can even at Google in quotation marks, just throw in Black's Law Dictionary. If you do, there are going to be many editions of Black's, but here's what's cool about that. You can find the ones that are relevant for the era you're researching. That's really valuable. And so go back, take a careful look. I use this constantly. All the free editions are out on the internet. I'm glad they are because I used to have a Black's Law dictionary, and let me tell you, they're massive. They're huge and they weigh a lot. So it's real nice to be able to refer to previous editions right out online. We're not going to talk about citizens' right of citizenship, but we are going to talk briefly about pension rights because these are some of the first things that women did gain. And they really helped to make a difference in terms of what women could inherit and what they had. They got pension rights beginning in 1832. Widows and orphans of Revolutionary veterans could claim unpaid pensions at that point. Now look, that's a long time after the Revolutionary War ended. So it took some time. Then there in between, in 1836, there was another federal act which provided for pensions to widowers just for 5 years at that point of Revolutionary War veterans who had married the veteran while he was in the service. Later, that was extended because those people said, hey, what about me? We got married after the Revolutionary War. Can I get this money? Yes, she could. In 1838, widows who married vets after Revolutionary service, but before January 1, 1794, they created that, could apply for pensions. They said, ooh, you know, what about these men who married 2 or 3 times after that war? This particular law was made to take care of that. And then by 1858, all widows of Revolutionary War vets who married after their service could apply. Well, of course they could, because there were not that many of them left. Just making a point here. Land rights, however, land rights were very, very interesting because remember, married women mainly gave up their rights to their land, at least for the husband's use once they had married. There was no problem if they were still single, they still had all their rights. But the US Congress, bless it, in 1841 put together a land act in which widows could apply for federal land, but married women could not apply for land in their own name. That was interesting. So you had to have been connected to that spousal unit and their land. In 1862, Lincoln's Homestead Act, single women over 21, widows and wives deserted by their husbands, you had to prove that, could apply for federal land. Isn't that interesting in that act? It still didn't cover everyone. But by 1878, the Married Women's Property Act existed in 37 states. Montana wasn't a state yet, so don't count on that. But it did exist here as a territory and the District of Columbia. So there were certain things that they were allowed to own. Personality, that is the personal property, the personality, I should say, the various things, again, were up for grabs. That is, if the husband had purchased various kinds of furniture or whatever, there were limitations to what she could have. By 1900, however, it's very interesting that in the Homestead Acts, this made a big effect on women in Montana and the West, but in Montana, in the Dakotas, also, Homesteads by Married Women Act protected an unmarried woman's rights for homestead entry after marriage. The land was hers, no matter what. If she had that land beforehand, she got married, he did not and could not claim her homestead land. That was a very specific instance. And thereafter, you see laws changing a great deal so that by the 20s, when we're really looking at lots of different kinds of rights for women, we're radically changing what women get to claim. And again, it's hard to believe, but there were a few states at that point. I can tell you for sure, Michigan was also included with those 3 other states in terms of women still being subject to dower for the things that weren't specifically named, like a homestead. when we look at civil rights and we look at citizens being treated as a citizen, I want you to remember that early on, if women married, they became a legal non-entity. So it took a lot before they could be a witness in a court, before they could serve on juries, before they could serve as an attorney. I found one particular thing in Cascade County in early 1940s, where it was a big deal because a woman was finally serving on an actual federal case in the jury. It was a big deal, and the woman was interviewed. And so we think of those as having happened a long time ago, but really, folks, that's only what, 80 years ago. Not even that, 75 years ago. And their rights, of course, for divorce, for various things, were up for grabs for a long time. So I want you to think about your female ancestors' time and context and make sure you record her rights, because it's going to help you. With Margaret Wart Cogleiser, my great-grandmother, having in her individual timeline, having her birth and her death and her marriage are helpful. Those are what we call the low-hanging fruit when we find them. But I definitely, in her timeline, I need to observe as a side note that when she lived as a child in Pennsylvania, married women did not have property or personality rights. That means her mom didn't either. And that means that there might be things that we could find with a case there, or even if her father died intestate, meaning without a will, that we might still find an inventory and find out what she was eligible to get or not get from that personal inventory. Certainly there would be, if there were land listed, she would be entitled to that 1/3 or so on. So that could be something very helpful. With Margaret, it's also going to be helpful for me to look at her moves. Her move to Ohio, her move 20 years later in 1870 to Nebraska, which was a newer state, and what that looked like, what kind of rights she had to her personal property, and what kind of rights she would have had to any kind of actual property, like such as land or a house, should she have survived her husband Zura. So that's what I'm going to have to be looking at as I look through court records in those three states, because she doesn't appear very, very many places. And I'm very, very curious about her. I'm going to be looking to see if I can find evidence of her in school voter records in Nebraska. I don't expect to find those, but we will see. I'm going to be looking to see what rights she may have had, or does she only appear in the Methodist church records there in Weeping Water, Cass County, Nebraska? Or did she join any female organizations? Can I find her in a newspaper by herself? It's frustrating because there were 3 Mrs. Cogleisers in Weeping Water, you see. So when they describe Mrs. Cogleiser as having attended a particular thing, they're not saying that it was Zura's wife or Sanford's wife or William's wife. They're just saying Mrs. Sanford, Mrs. Cogleiser. So I'm going to have to investigate even more closely. I know they're connected, but there's a real challenge there for me. We'll be talking about, whoops, guess I'll go back and stop that particular share. But thinking about a female ancestor's time and context with regard to dower and property is very interesting. In some states early on, they regained those rights. You will find some very interesting information regarding New York, which is where those rights to property and rights to personal property, their very own personal property, first really gained traction. And other laws, other states then began to follow them and to look at those particular laws. But I find it very interesting that when we look at inheritance in America, and that's this book again, when we look at inheritance in America, there's extreme variance among all the laws even today. So you have to look very, very carefully. You don't assume from one state to the next what you've got. I assumed, for example, that the laws for the states that all came into the United States together as territories in 1889, that would be the two Dakotas, Montana, Washington, for example, that their laws would be very different. Washington's laws are very, very much more liberal than the other states. It's just a very, very interesting thing to look at to see what they brought in, considering that they all had similar laws when they were territories. So their laws were very similar with regard to women's rights when they were territories, but they really changed as they wrote those state constitutions. So it's worth looking at it, and then worth looking at what happened in each state, because it still matters today. I would ask that one of the things that you do is that you look carefully at your female ancestors to see what it was that they may have gotten, especially if you know that land came down through the family, because when land came down through the family, I can find evidence in Pennsylvania finally where land came down through Zura's, not Zura's family, but his parents' family, and they all wrote a quit claim deed and gave the property to one sister. That was highly interesting because they walked around the actual law of the land at that point and said, no, we believe this sister should have this land. She's been there. She's been whatever. So 7 people signed a quit claim deed and quit that land and said they had no right to it, even though Pennsylvania law would have given them right to it at that point. So the law cases, or even just when you see that a particular probate or a particular will is being probated, go look at those. Get that particular set of documents, because I have a hunch they'll be very interesting to you. I have ended this, at least for my purposes, in terms of giving you information. So, all right. Other questions? Anything else for whatever questions that you have? Sure, good to see all of you. Very good to see all of you. Hope to see you again. And we'll sign off for today then. Thanks so much for your time.
Thank
Thank
you.
you.
Jan. Thank you very much.
You betcha.